I would like to cover a clarification issue, a terrorist financing matter, and information sharing. On the classification issue, I'd like to ask about the FBI and Justice Department going back in time and classifying information that Congress was given in briefings 2 years ago. This information involves a whistleblower by the name of Edmonds, a translator who was fired from the FBI because of problems pointed out. 3 issues. I'd like to raise all 3 and then have you address them. First, what was your involvement in the decision to retroactively classify information already given to Congress if you had an involvement? Second, who made this decision, civil division lawyers or operational people at the FBI? And third, laws and executive orders have requirements for how information's classified. So since we do have those laws and executive orders, could you explain how the FBI and the Justice Department followed those requirements in this case?
If I'm not mistaken, in the matter to which you make reference, the national interest of the United States would be seriously impaired if information provided to the in one briefing to the Congress were to be made generally available. And in order to protect the national interest, a decision was made to classify the information. I take responsibility for that decision.
Okay.
And I believe, and I have reviewed the matter within the last couple months. I think at your request, or a request of a letter on your part. I'm not sure if we've talked about this personally, and that's the reason for which the decision was made.
So you made the decision so civil division lawyers or operational people, the FBI, wouldn't have been involved in that?
I don't know that they would have been uninvolved. It may be that my decision was shaped based on recommendations of theirs and the participation that they would have had in some measure, but it relates to both a lawsuit which is underway and the national interest, the security interests of the United States.
Isn't it a little ludicrous, though, saying that you classify this information now, though, because it could, if it was exposed to the public at large, if I were briefed on it and I were not told that it was secured or anything, I could have been talking about it for the last 10 months and it could have been out to the public. So
that's exactly right, Senator.
But I mean, I could have been because it was just recently reclassified. So I could have done that. So isn't it ludicrous to classify it now?
Well, if, let me just put it this way. If there is spilt milk and there's no damage done, if you can recollect it and put it back in the jar, you're better off than saying, well, it's spilt, no damage has been done, we might as well wait until damage is done. Okay. Our responsibility is, if information is made available, which is against the national interest to be in the public sphere, to say we should do what we can to curtail the availability of the information. It's on that basis that I made the decision.